In February 2026, one report in particular exposed what authorities are calling one of Australia's largest construction corruption scandals. The report alleges that Victoria's CFMEU branch operated as a crime syndicate, with massive taxpayer funds allegedly wasted. Tens of millions of dollars were allegedly wasted through systematic corruption, infiltration by organised crime, and procurement fraud. While this originated in Victoria, Queensland businesses now face heightened scrutiny, new compliance obligations, and significant legal risks. I'm John Merlo, and I'm here to break down what this means. The report, prepared by Jeffrey Watson SC, was made public in February 2026. It alleges that under certain leadership, the Victorian CFMEU branch was infiltrated by outlaw motorcycle gang members. The report claims it facilitated systematic extortion of construction companies and inflated project costs through corrupt practices. This included false invoicing, sham labour arrangements, and deliberate cost inflation on projects like Victoria's Big Build program. Following the report's release, Task Force Hawk arrested a former CFMEU delegate on serious blackmail charges. The arrest allegedly involved a massive extortion plot by an alleged motorcycle gang member. It's critical to note, these are allegations and investigations are ongoing. We must wait for the full legal process to conclude. Remember, all individuals are presumed innocent until proven guilty in a court of law. Scrutiny is exceptionally high right now. From July 1st, 2026, Australia expands anti-money laundering obligations under what's known as Tranche 2 reforms. This is significant. These new laws bring lawyers, accountants, and real estate agents under much stricter reporting obligations to the government. Even if your company isn't a reporting entity, you'll be affected as your partners must verify beneficial ownership of transactions. The professionals you work with will now conduct enhanced due diligence and report any suspicious activities directly to AUSTRAC. Construction has been identified as a high-risk sector for money laundering, requiring heightened vigilance from all stakeholders. Common typologies include false invoicing for non-existent work, ghost workers on payroll, and inflated variation claims. Authorities are also watching for complex trust structures designed to hide beneficial ownership and avoid banking oversight. What should you watch for in your projects? Here are 5 critical red flags that demand your immediate attention. First, contractors requesting cash payments over $10,000. This is a primary indicator of suspicious activity. Second, invoices with vague descriptions or suspiciously round figures that lack clear detail or breakdowns of work. Third, beneficial ownership of companies that is difficult or impossible to verify through standard corporate checks. Fourth, payment requests to offshore entities without a clear business purpose or justifiable reason for the transfer. Finally, labour hire firms requesting payment for workers that cannot be verified as actually performing work on site. If you see these patterns, document them, seek legal advice immediately, and consider whether reporting obligations apply to you. Queensland construction businesses now face intense scrutiny from multiple integrity bodies at all levels of government. At the federal level, the National Anti-Corruption Commission, NACC, investigates corruption affecting Commonwealth administration. In Queensland, the Crime and Corruption Commission, or CCC, has jurisdiction over state projects and council developments. Core bribery offences under Commonwealth law carry penalties of up to 10 years imprisonment for offenders involved. This includes both domestic bribery and foreign bribery under Division 70 of the Australian Criminal Code. It is serious. Now here's what most construction businesses get wrong about gifts and hospitality. It's not about the dollar value, it's about context, intention, timing, and your role. The Queensland Crime and Corruption Commission is explicit. If your staff are in high-risk roles, procurement officers, contract managers, project approval positions, They should decline any gift or benefit from suppliers, contractors, or parties who could benefit from their decisions, regardless of the gift's value. Why? Because even a $20 lunch can create a perception of obligation or influence when someone is making decisions about millions in public contracts. The test isn't, how much is it worth? The test is, could this gift be perceived as intended to influence decision-making? Is it being offered because of the recipient's role? Could accepting it create a real or perceived conflict of interest? Now, 3 specific high-risk scenarios you must address in your business. Scenario 1. Gifts to government officials. Any gift above token value, and in some contexts any gift at all, can be bribery if it's intended to influence or create obligation. Your anti-corruption policy should set clear approval processes, require disclosure in a gift register, and prohibit gifts during active procurement or tender processes. Scenario 2. Facilitation payments. These are payments made to expedite routine government services. They're illegal under federal law. Zero tolerance. No exceptions. Scenario 3. Union pressure for preferred subcontractors. If union officials suggest preferred contractors and imply delays, industrial action, or site disruptions if you don't comply, and threats are involved, this may constitute extortion. Document every interaction, refuse the demand, and report to police. Now, your business needs 2 critical compliance systems in place. First, an anti-corruption policy. This sets clear standards for what your team can and cannot accept. It should include prohibited gifts and benefits, approval thresholds and processes for any gifts that can be accepted, reporting requirements when offers are made, and consequences for breaches. Second, a gift register, a transparent record where all offers of gifts, benefits, or hospitality above a minimal threshold are disclosed, whether accepted or refused. This creates accountability and allows you to identify patterns of attempted influence. The principle underlying all of this: if you wouldn't want the gift, benefit, or payment published in tomorrow's newspaper, don't accept it. Transparency is your protection. Understanding when and where to report is critical for your protection and compliance in this new construction climate. Reporting entities must file suspicious matter reports as soon as practicable after forming any suspicion of illegal activity. Cash transactions of $10,000 or more must be reported within 10 business days to Austrac systems. Contact the NACC for federal matters, the CCC for state issues, or the Fair Work Ombudsman for union misconduct. Report immediately to police if there are threats of violence, extortion, or evidence of organised crime infiltration. Whistleblowers have significant protections, including anonymity and immunity from civil liability under the law. Protections also cover retaliation, provided the person has reasonable grounds and discloses to eligible recipients. Queensland's Public Interest Disclosure Scheme provides similar protections for reporting public sector matters to the CCC. Queensland has its own high-risk projects that are currently under intense regulatory scrutiny across the state. Cross River Rail, a $5.4 billion project, is one of the key sites under watch by authorities. The Brisbane 2032 Olympics infrastructure program also involves significant federal oversight and total transparency. Renewable energy projects involving government investment also require enhanced compliance and total transparency from contractors. If you're working on major Queensland projects, you must implement enhanced compliance measures immediately. Act now. To help you navigate this, I've developed a practical 90-day action plan for your business operations. This plan provides a structured roadmap to ensure full compliance and protect your operations from legal risks. In the first 30 days, conduct a comprehensive risk assessment and brief senior management on new obligations. Ensure all decision makers are fully aware of the new regulatory landscape and the risks associated with it. During days 31 to 60, implement enhanced due diligence procedures for all of your contractors and partners. You should also conduct staff training on red flags and update your formal contractor onboarding process. Do it thoroughly. In the final 30 days, update all contract templates with specific anti-corruption and audit clauses. Essential for safety, establish formal reporting protocols and test your internal systems with various scenario planning exercises for your team. Your contracts must require verification of contractor legitimacy and the true beneficial ownership of companies you hire. Include anti-corruption warranties, audit rights, and clear termination triggers if criminal associations are discovered. Protect your business. Here's what you can do this week. First, conduct a thorough compliance audit of your current internal systems. Review your contractor vetting procedures, payment controls, and reporting protocols against these new legal standards. Second, update your policies. You need an anti-corruption policy with zero tolerance and clear reporting procedures. Address AML compliance, gifts, and procurement integrity measures immediately in your documentation. Third, train your team. Your managers and procurement staff need to understand red flags and legal protections. Ensure everyone understands the legal reporting obligations and the protections available to them under the law. Fourth, review your major contracts. Are your current agreements adequate for these anti-corruption standards and risks? Finally, seek specialist advice. This is complex, and you need advice specific to your business circumstances and needs. The construction industry is entering a new era of scrutiny. Act now to protect your business and reputation. Queensland businesses that act now will be protected. Those that wait risk significant legal consequences. Stay vigilant. If you found this valuable, please like the video, subscribe, and share it with your industry colleagues today. At Merlot Law, we're offering comprehensive compliance reviews. You can reach me directly on 0431 813 950. This video is for information purposes only and does not constitute legal advice. Obtain specific legal advice for your circumstances. The allegations discussed have not been proven in court, and individuals are presumed innocent until proven guilty.